Madam Deputy Registrar, can you please call the matter?
Good afternoon. Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Guyana, judgment delivery in GYACR number 2 of 2023 between Sherwyn Harte, Deon Greenidge, and the state. The delivery panel this afternoon will be Mr. Justice Saunders, our president. May we have the appearances, please? Thank you.
Very good afternoon, Mr. President and your honors. I'm Ronald Daniels. I'm led by our senior counsel, Mr. Douglas Mendes, King Counsel, Mr. Joseph Middleton, and Mr. Hughes, who is regrettably absent. And together we appear for the applicants.
Yes, thank you very much.
Thank you kindly.
Good afternoon, all. May it please Your Honor, Natasha Bakker, Assistant Director of Public Prosecutions, together with Mrs. Shalimar Ali Haq, Senior Counsel, Director of Public Prosecutions, for the respondent. We apologize for the absence of the two attorneys on record, but regretfully, they're both out of the jurisdiction.
Yes, good afternoon.
Good afternoon. Sorry, Your Honor.
Unfortunately, my colleagues, Justices Witt and Anderson, are unable to be with us this afternoon, but the judgment which I am about to deliver is a judgment authored by Mr. Justice Anderson, but it is concurred in by Justices Witt and myself, by Justice Witt and myself. I will read a summary. In 2013, the applicants and the third person, who were all male members of the Coast Guard Division of the Guyanese Defense Force, were indicted for the murder of Dweeb Kant Ramdas under Section 100 of the Criminal Law Offences Act. Prosecution's case was that the men robbed Mr. Ramdas of money and threw him overboard during a stop and search exercise of boats in the Parika area, and that Mr. Ramdas drowned. Section 100 of the CLO Act, Criminal Law Offences Act, provided for the mandatory sentence of death on conviction for felony murder. This section was amended in 2010 to Section 100A, which provides that a person convicted of murder in the course or furtherance of a robbery may be sentenced to death or to imprisonment for life. The applicants and the third person were tried and convicted before Justice Holder and sentenced to the mandatory death penalty under the unamended Section 100. The three men appealed to the Court of Appeal against their convictions. They also appealed against the constitutionality of the death penalty, and the Attorney General participated as an intervener in rebuttal. Court of Appeal unanimously upheld the convictions, but vacated the original death sentences and replaced them with life sentences with tariffs. Before this court, the applicants applied for special leave to appeal against the decision on sentence of the Court of Appeal and sought to obtain an order from this court declaring the death penalty to be unconstitutional per se, and that it could not be lawfully imposed in Guyana. The second applicant also sought special leave to appeal his conviction. This court held firstly that the second applicant did not establish any realistic possibility that a potentially serious miscarriage of justice may have occurred by virtue of his conviction for murder. There was ample evidence in the caution statement and the circumstantial evidence on which a jury, properly directed, would have reached the conclusion that he was party to the joint enterprise to rob and murder the deceased. Secondly, in relation to the constitutionality of the death penalty, the court found that the applicants faced no threat of execution, and so the arguments raised on this issue were entirely academic in nature. The court reaffirmed this decision in the Yakshi Conservation Trust against Sabido, that it would only hear academic appeals in specified exceptional circumstances. The current application did not fall under those exceptional circumstances. Thirdly, as regards the applicant's argument that the reasoning of the Court of Appeal considered the death penalty as being a saved law, the court indicated that its case law had expounded clear views on the savings law clause in Guyana. And naturally, to the extent that there is any variance between those views and the reasoning of the Court of Appeal, the views of this court must prevail. Fourthly, the applicants had contended that the Court of Appeal had not adhered to the proper sentencing methodology in vacating the death penalty and imposing life sentences with tariffs. The court considered that a normal sentencing hearing would probably not be practical 9 years after the indictment and conviction. However, the court held that in respect of future cases, there ought in principle to be a resentencing hearing, which could be brief, in which counsel on both sides were asked to indicate factors relevant to the resentencing exercise. In the present case, the offenders were members of the Guyana Defense Force who had robbed and murdered an innocent citizen. There was no ground for regarding the sentence imposed as excessive or so manifestly outside the mainstream of sentences. Even more pertinently, on a conviction for felony murder, the unchallenged Section 100A of the CLO Act, Criminal Law Offences Act, only attracts two sentences, death and life imprisonment. Where the court imposes life imprisonment, as in this case, the section requires that the court shall specify a period being not less than 20 years, which the convicted person should serve before becoming eligible for parole. This means that if the court imposes the minimum of 20 years, there is no space for consideration of established sentencing principles, including mitigating factors. In this case, the court had imposed a tariff of 18 years, which appears to conflict with the statutory minimum. However, in all the circumstances, this court decided that given that special leave application is being dismissed, it would not intervene to bring the tariff in line with the statutory minimum. In all the circumstances, the court ordered that the application for special leave be dismissed, and it would make no order as to costs. Apparently, Mr. Hawke is missing from the appearances.
Sorry.
But I know that you're there with Ms. Clark from the AG's office, and I thank you very much for your attendance.
Okay.
Yes. In the absence of anything further from counsel, Madam Deputy Registrar, you may close the proceedings.
Thank you, President Saunders. Thank you, counsel, and a thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you so very much.